Today, I'm going to talk about updates in U.S. immigration as well as answers to some questions about the public charge from one of our YouTube viewers. For those who are turning in for the first time, my name is Andres Mejer. I'm an immigration attorney and an immigrant. I went through what many of my clients experience on the way to becoming a U.S. citizen. I came to the U.S. on a visa with my family. We overstayed our visa and lived without legal status for almost a decade. I was able to get a green card through amnesty, and I got my citizenship in 1999. I experienced the stress that comes from not having legal status and from hiring an attorney who doesn't do anything for you. That's why my goal is to help those who hire us to never feel that stressed out. I want your journey to become a U.S. citizen or a lawful permanent resident to be as smooth and as easy as possible. What I wish my family had experienced rather than a disaster that we had to go through. If you like these videos, please subscribe to our channel and hit the bell to be notified when new videos come out. If you need help with your immigration matter, call or email us and we'll see if we're a good fit. So what else is going on in the US with immigration? While Republicans seem to be splitting into two parties with their internal fighting, President Biden is moving ahead quietly, implementing policies and procedures to help the US. One thing that happened on February 3rd was the Supreme Court granted the administration's request to drop the oral arguments for two immigration cases from its calendar, and the Supreme Court agreed. One, Mayorkas versus Innovative Law Lab. This case addressed whether the migrant protection protocols, aka the remain in Mexico, which meant people applying for asylum had to remain in the first country they came to that was not their own, in most cases was asylum, while their asylum application was pending. So that argument that the migrant protection protocols were lawful and if it was exempt for the Administrative Procedure Act. The other case is Biden v. Sierra Club. This case dealt with appropriating funds from the military to build the border wall. Trump couldn't get Congress to authorize money for the border wall, so he went around them by appropriating money from the Defense Department. He just did whatever he wanted. Technically, the cases are still in front of the Supreme Court, and the court could place them back on the calendar. But since the court agreed to remove them from the calendar now, it is more likely they will be disposed of without a decision. President Biden had issued executive orders on his first day in office, pausing construction of the border wall and the Remain in Mexico policy. The request of the Supreme Court asked the oral argument that were scheduled for February on both cases be postponed while the administration reviews the policies and decides what to do going forward. There's one other really important update I want you to be aware of that USCIS recently shared on their website. On January 28, 2021, USCIS announced that they would extend the flexibility for responding to agency requests. This has been happening since March of last year due to COVID. You must have gotten one of these notices from USCIS between March 1st, 2020 and March 31st, 2021. So we're talking about requests for evidence, continuations to request for evidence, notice of intent to deny, notice of intent to revoke, notice of intent to rescind, notice of intent to terminate regional centers, motions to reopen, and then 400 due to derogatory information after grant. So basically, it's where USCIS is going to do something and notifying you, hey, I need more information. I think your case is approvable, but I need more information. Or we're intending to deny it, but I'm giving you an opportunity to address it. Or we already granted you the relief, but now we have new information and maybe we're changing our mind. So any of those notices that are sent to you, you have a certain period of time that you must respond to them. Well, that time is being extended, the time to response, because of the pandemic. So USCIS will now accept responses that are received within 60 days of the response date in the notice. So for example, if you get something on January 1st and you're told you have to respond to within 84 days or 33 days, you will now have an extra 60 days. That doesn't mean that if you are notified in March 1st, you can still respond to the information March 1st, 2021, a year later. No, you get an extra 2 months to respond, but after that time, your time is up. So what does this mean? It means, again, you have more time to respond Now, they may update this after March 31st as well, since they've been extending this since it was first put into place, but we're going to have to wait and see what happens. We have good news for student visa holders. The OPT, the Optional Practical Training Program, which lets international students remain in the U.S. for up to 3 years after they graduate, survived a legal challenge to its extension. U.S. District Court Judge for the District of Columbia, Reggie B. Walton, ruled that the Department of Homeland Security, DHS, had not overstepped its authority by expanding the OPT program despite labor union who sued them, the Washington Alliance of Technology Workers, or Washington Tech, claiming that it had. We've had several people ask if President Biden is going to be giving international students a path to citizenship. As we've replied to those questions, we haven't seen or heard any evidence of this. It's good news that the administration has dissolved the organization within ICE that was reviewing the OPT program, but I wouldn't extend this to him saying that he will give international students green cards and citizenship. Now, keep in mind, international students have legal status, so they do have other options of ways to get a green card. What these people are asking is, will there be a separate path for students just by virtue of being here? And at the moment, it does not seem that there will be. I wanted to answer a few questions from one of our viewers on YouTube about the public charge, because I know this is something many people are wondering about. Zach Obut said, "Dear Andres, you mentioned that the courts have already stopped public charge rule. Does this mean that the green card applicants don't need to include the I-944 forms when submitting I-45?" Zach asked several weeks ago and then followed up with this question. "Hi Andres, I would like to ask further explanation about this issue if you don't mind. In my case, I'm from Massachusetts. My understanding, having checked a number of sources, we still need to file I-944. However, my lawyer from Virginia said that I-944 form is not required. Please educate me on this one. Thank you very much." Let me first be clear. Unless you have hired me and I have reviewed your case and know your personal circumstances, I am rarely going to contradict the advice of your personal attorney, unless what they say is clearly wrong. If you don't trust the attorney that you hired and you don't believe that they're giving you accurate advice, you need to talk to them or hire a new attorney that you do trust. But let's go back to your question and let's talk about the public charge. For those who don't know, the public charge is one ground of inadmissibility. That means if you don't meet criteria, you would not be admitted to the United States because you're not admissible, or in other words, not eligible. So this normally comes in the context of you applying for a green card, not applying for citizenship, because if you're applying for citizenship, you already have your green card. The Trump administration tried to put public charge rule into effect. It required that you prove you were able to take care of yourself financially before being able to come to the United States. This is not new. This has been required by immigrants to the U.S. since the 1880s. The public charge policy put many more restrictions on people, and I, as well as others in the immigration community, felt like it was a backdoor way for the last administration to end legal immigration. What they did is define what is the public charge. Now, the public charge existed for a long time, as I said, but now they expanded it and they defined it. But in order to answer or to address Zach's point, I think it's important that we provide some context. So let me give you a timeline of the public charge. In January 2018, Department of State updated their Foreign Affairs Manual on the public charge. In October of 2018, DHS published a proposed change to the public charge rule in the Federal Register. On December 10, 2018, with over 260,000 comments submitted on the proposed change, the public charge period was closed. On August 4, 2019, DHS published a final public charge rule with an effective date of October 15, 2019. Between October 11th and October 14th, several courts issued preliminary injunctions. That means they temporarily stopped the rule from going into effect. January 27, 2020, the Supreme Court lifted the final injunction against the public charge rule going into effect. DHS said that the rule would go into practice on February 24, 2020, except in Illinois. On February 21, 2020, the Supreme Court lifted the injunction in Illinois as well. February 24, 2020, USCIS starts implementing the public charge rule, and those who are required to file an I-944 must do so with their application. On July 29th, 2020, the Public Charge Rule and the Foreign Affairs Manual were enjoined nationwide due to the COVID pandemic. So a court said, you're not applying this because of COVID. In August 12th, 2020, the Second Circuit limited that injunction to New York, Connecticut, and Vermont, basically limited only to the Second Circuit. On September 11, 2020, the Second Circuit lifted the nationwide injunction. On November 2nd, 2020, the federal district court vacated the public charge rule and said the DHS cannot use the new rule in any case, and that was true nationwide. On November 3rd, 2020, the Seventh Circuit says that the order from the Second Circuit, and on November 3rd, the Second Circuit said to the Second Circuit decision and indicated that DHS can implement the new rule nationwide during the appeal of the decision. You think this is confusing? Boy, it is. On December 2nd, 2020, the Ninth Circuit stopped DHS from implementing the rule in many jurisdictions, but not all. California, Colorado, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Jersey, New Mexico, Oregon, Pennsylvania, Rhode Island, Virginia, Washington, D.C., and Washington State. But the injunction is not in effect until the mandate passes. Add into the confusion from USCIS saying they would not enforce the public charge rule, then saying they would enforce the public charge rule, and then saying it was now retroactive to anyone who applied since February 2020, and people are understandably confused and concerned. So where are we today, February 2021? Remember, the public charge does not apply to all immigrants, nor does it apply to those who are filing for citizenship. It also doesn't apply to those who had to get treatment for COVID. The Department of State is not able to and has not been able to enforce the new policy since July 2020. That means if you're applying for a status and you are outside the US, public charge rule does not apply to you. In December 2020, the Department of Justice withdrew its public charge rule, inadmissibility and deportability on public charge grounds from the Office of Immigration and Regulatory Affairs. President Biden signed an executive order saying that public charge should be reviewed, but he has not ended it yet. If you are applying for an adjustment of status or other immigrant benefit that required the I-944, you should file one unless you're in a state that were enjoined from enforcement by the Ninth Circuit in December. So Zach, if you are in Massachusetts, as your attorney said, you shouldn't have to file Form I-944. I think what many people fail to ask, and that's really important to determine, is it going to hurt you if you file one and don't need to? What is the standard attorney answer? It depends. The fact is, some of the policies set in place by the last presidential administration gave more discretion to USCIS officers. Therefore, they may consider what you have submitted and use that against you. What would I tell you if you were my client? Well, I would tell you not to file if you're not required to do so, as you don't want to give USCIS any reason to deny your application. I want to share another great win for one of our clients. I'll call her Maria. That is not her real name. Maria grew up in Mexico to parents who were farmers. They were struggling to survive there, so she came to the US when she was a young adult, and she came all alone. She entered the US without inspection. That means she didn't have legal status. She came illegally. She worked and sent money back to her parents in Mexico. In 2013, she married a US citizen. They had 3 children, and one has severe mental and physical disabilities. Our office was hired by Maria and her husband in December 2017. We filed her I-130 in April 2018. So that only took 4 months to get that filed. Now, that's where we present that it's a legitimate relationship. The I-130 is the first step where Maria and her husband must prove that their marriage was for a legitimate reason and not just to receive an immigration benefit. I like to tell you the times and dates so you'll have an idea of how long it might take for you. The I-130 was filed in April 2018 and it was approved December 26, 2018, or about 8 months later. We then filed an I-601 waiver in August 2019, asking USCIS to forgive her being in the US over 1 year without permission. Remember, she entered illegally, so when she leaves, she would be ineligible to return to the US for 10 years unless and until she filed for a waiver and it was approved. The I-601 waiver was approved on January 25th, 2021. That took an exceptional long time. August 2019 to January 2021. Obviously, COVID happened in between, but still. What happens now? So her next step is we're going to file DS-260 with the Department of State, and we're going to provide supporting documents. We'll get a notification that she has an appointment at the U.S. consulate in Ciudad Juarez. She must then go to Mexico and have an interview there. At the interview, they will confirm the information she has previously submitted, and there's nothing that makes her ineligible to return to the U.S. Then she'll need to wait for the Department of State to forward her passport with the visa, which will indicate her green card status. This is sent to a DHL service center, and she'll be able to pick it up in Juarez. The time this takes varies, but it usually, at least pre-COVID, was 1 to 2 weeks to get permission to come back to the U.S. When she enters the U.S., she'll get a permanent green card since she's been married for over 2 years. If it had been less than 2 years, she would get a conditional green card. Once she has been a permanent green card holder for 3 years, we'll be able to help her to become a U.S. citizen. Waiver cases are complex. I highly recommend you hire an attorney if you need one, because you must prove extreme hardship to a qualifying relative. There are many factors that go into a waiver, but we typically focus on 3 core factors: financial, emotional, and medical hardship to your qualifying relative. What I tell clients is if you have at least 2 of them, you have a strong, compelling waiver case. Now, we've done it with only 1, but again, that's the less you have, the harder it is to get approved. Now, qualifying relative is a spouse or a parent who's a U.S. citizen or lawful permanent resident. Children don't count. And it's really important because children can file for you at the I-130 stage, but they can't be the basis for a qualifying relative. And if you don't have, for a waiver purposes, if you don't have a means to get a waiver, that means if you leave, you won't be able to come back, which if that's your case, you're better off not doing anything. So my paralegal put this in an intelligent way. She said, if you look at the 3 parts that we must prove, financial, emotional, and medical, as 3 little grains of sand. Our office creates a huge amount of legal support from just 3 little grains of sand for you to be approved. Congratulations to Maria and her family. We are so happy to have been trusted enough to help them in their immigration journey. That's it for today. Thanks for everyone who likes, comments, and shares on our videos. We love reaching and helping more people, and you help us do that. If you need help with your immigration journey, call us. Stay healthy and be well.